decision specifically. And on the issues we looked at, the confidential human source decisions, the Phiza decisions, and the opening, we found that they were not the decision maker on them, so that we could segregate out their views and their activities from those decisions.
All right, thank you. Let me just follow up. During your appearance before the Senate Judiciary Committee last week, Mr. Strzok and Ms. Page were described by some of my colleagues as, quote, the people in charge, close quote. For witness, your team interview stated that Mr. Strzok was in fact not the primary or sole decision maker on any investigative step in Crossfire Hurricane. Witness was Ms. Page, quote, did not work with the team on a regular basis and make any decisions that impacted the investigation, close quote. Is it fair to describe Mr. Strzok and Ms. Page as the, quote, people in charge, close quote, of the Crossfire Hurricane investigation?
So Ms. Page was not in the chain of command at any point in time. Mr. Strzok was in the chain of command, so he was did have supervisory authority for a period of time. He rotated off the organizational chart in roughly January when the second team came into being. And there were a series of problems that occurred after that as well. And so I think he's in a different position in terms of the chain of command, certainly, than she was.
In March 2017, President Trump alleged that, quote, Obama had my wires tapped, close quote, and Trump tired just before the victory, close quote. Later, he retweeted a statement that the, quote, DOJ put a spy in the Trump campaign, close quote. Attorney General Barr repeated these accusations in April this year when he testified that he thought, quote, spying did occur, close quote, on the Trump campaign. I would just ask Mr. Horowitz, did you find any evidence that the FBI engaged in spying on the Trump campaign?
So we're very careful to use the words, the legal words that are used here, which is surveillance. There was the Carter Page surveillance that we've identified here. We did not find evidence of other court-authorized surveillance. We found the confidential human source activity that we detail here and didn't find additional confidential human source activity prior to the election.
If I could close with this, did the report find that the FBI engaged in surveillance of Trump Tower?
We did not find evidence of surveillance on Trump Tower.
And did the report find that any monitoring of Trump campaign officials occurred without necessary FBI approval?
All of the monitoring activities were approved.
And is it fair to say that the statements by President Trump and Attorney General Barr that I've described are incorrect?
Again, we don't use the term spying. We're looking at whether there was court-authorized surveillance or not. So,
thank you so much.
Stick to what we have here.
I want to go back to October 11th's activities. After being asked 3 times by Department of Justice Attorney Stu Evans, the FBI finally responds, quote, that Steele had been paid to develop political opposition research. In your report, you write that Strzok has advised Page support from McCabe might be necessary to move the Phiza application forward. Strzok texts Page, currently fighting with Stu for this Phiza. The following day, Lisa Page texts McCabe, I communicated you and boss's green light to Stu. I communicated, I guess it's your, and boss's green light to Stu earlier. I've not heard back from Stu in an hour. I will invoke your name to say you want to know where things are. Isn't that pretty high-level pressure on Stu Evans by Peter Strzok, Lisa Page, and Andrew McCabe?
There was certainly that effort, exactly as you described. What ultimately happens is McCabe speaks with the head of the National Security Division about it. So they ultimately don't need to do what they're talking about here. But that is absolutely what they're talking about.
I want to go back to pick up a little bit what Senator Langford was talking about with Bruce Orr. These are quotes in your report by senior Department of Justice and FBI officials describing Orr's ongoing interactions with Steele and the FBI. And these are just basic descriptions of how these officials thought about it. Quote, outside of Orr's lane, they were stunned, they were uncomfortable with it, out of the norm, bad idea, raised red flags, flabbergasted. FBI should have alerted DOJ. Shocking, inconceivable. That's, again, those are a lot of senior Department of Justice FBI officials. What was interesting is how Andrew McCabe responded to Orr's activity. He said, this is a responsible thing to do. How do you explain that discrepancy from most of the FBI and Department of Justice officials and Andrew McCabe thinking, not a problem, it's a responsible thing to do?
Yeah, look, I can't explain why that view would be there. I think it's perfectly understandable why, if you are in the Deputy Attorney General's office, whether you're the Deputy Attorney General or right below the Deputy Attorney General, to have someone on your staff doing what was going on and not telling anybody is highly problematic. And as we point out here, the net result of that is the Deputy Attorney General was signing a warrant that did not include key information that someone on her staff knew and had told the FBI, but the FBI had not come back and told the Justice Department. That was the net outcome of that. That's a problem.
Look, I'm seeing Andrew McCabe's fingers all over this thing. I'm also seeing him saying he can't recall 26 times on significant issues. I'm not buying it. Let me go back to State Department involvement. I realize that you're limited, but I just want to ask some questions. Are you aware of why high-level State Department officials meeting with Steele and forwarding his reporting to the FBI? Why were they?
The only thing I could say is from speaking with Ms. Kavalek, it was because she thought she had to tell them because they needed to know. But as to the others, why they were doing what they were doing, I don't know.
So did you obtain any information, meeting notes, or any other documentation based on those meetings and contacts?
We obtained certain information from the State Department, including, for example, Ms. Kavalek's notes, and we were able to speak with her.
You did request interviews with Jonathan Weiner, right?
Correct.
Do you know why he refused to cooperate?
I don't know.
Why did you want to interview him? What information did you feel he had that you wanted to know?
Precisely because of his interactions with Mr. Ward and Mr. Steele, much like we want to talk with Ms. Kavalek, because we wanted to tie off an understanding as to what was happening between the Justice Department and the State Department.
On September 30th, 2016, Peter Strzok texts Lisa Page, quote, "Remind me tomorrow what Victoria Nuland said." Did you ever find out from Lisa Page what Victoria Nuland had told her somewhere on or about September 30th?
I don't recall, as I sit here, whether we heard about it. I'd have to follow up with that, Senator.
Senator Peters, do you have? I'm going to organize my thoughts here. Do you have some other questions?
I do. Yeah, thank you, Chairman. Mr. Horowitz, in addition to your role as the DOJ Inspector General, you also serve as the chair of the Council of Inspectors General on Integrity and Efficiency. So kind of a question. I know you've addressed this somewhat with a previous question, although I was out voting at the time. If you could speak a little bit again to the importance of the Inspector General independence, and in particular why SIGI is important to the work of Inspectors General, and what we need to do to strengthen that organization as it ties into the general theme of why independence is so important. That would be very helpful.
Absolutely. So the foundation of what we do as Inspectors General is our independence, is our ability to both report to our agency heads and Congress about what we find. We're not, very importantly, untethered from the departments we're in, but rather serve that dual purpose and that ability to report to both. And the independence is critical because we have the ability to get information like we did here, to use our own judgments without influence from the leadership of the Justice Department, the FBI, or others, but to make unbiased decisions based on our historical reviews of department activities. And that's critical. The foundation also is our ability to be transparent and our ability to produce reports like this so the public can decide for themselves what they think of our factual findings, which hopefully are 100% accurate. And I note here no one's taking issue with our factual findings, but rather inferences drawn from them. And that's critical. So we've got to be able to do that. We've got to be able to have robust dialogue, as I mentioned earlier. The fact that I may disagree or the Attorney General may disagree with me, it isn't a problem. In fact, it, in some respects, demonstrates the importance of our independence and our independence. Some of the things that SIGI does and the Council of Inspectors General does that's important is pull together all 73 federal IGs and bring us together for common goals, common purposes, common issues that we should have oversight of, training, but most importantly, being able to advance independence and transparency in the government, represent the taxpayers in our agencies, support the ability to get information out there to the public so that the taxpayers know where their money is going, how their money is being used, whether programs they're authorizing, in this case Phiza, that are highly intrusive programs are being used wisely or not being used wisely, and making recommendations to fix them, and then doing follow-up to make sure that's done, and being able to come up here, frankly, like I did for many years before this committee and the chairman on access to records and other issues that we were having problems with so we could do our jobs. In fact, this committee, as it's aware, this report wouldn't have been possible but for the IG Empowerment Act that you all passed, because this was one of the areas we were being hamstrung and being able to oversee. And so that's the kind of independence we need. We need, for the reasons I mentioned earlier, testimonial subpoena authority. We can't get relevant evidence at key times, including when individuals resign on the eve of being questioned by IGs. Contractors who get sometimes tens, hundreds of millions of dollars, at some agencies billions of dollars in contracts potentially. And grant recipients who get a considerable amount of money. So there are a lot of tools we need to further our efforts. The committee's always been very supportive of our work, and I certainly appreciate it. I know as chairman and ranking members, you both led the way on that for us.
Mr. Horowitz, as our committee states in questionnaires that we present to every nominee who comes before us, quote, protecting whistleblower confidentiality is of the utmost importance to this committee, something that, as you know, is absolutely vital for us to do our work in oversight. But why, in your words, why are whistleblowers important, and why is protecting whistleblowers of critical importance?
So precisely for the reasons you indicated, Senator, we get a significant amount of our information from individuals who are willing to blow the whistle. Some call themselves whistleblowers, some don't call themselves whistleblowers, but they're willing to come in and blow the whistle on wrongdoing and misconduct. In July, we issued a report at CIGI, the Council of IGs, it's on our website, about cases that move forward precisely because whistleblowers were willing to come in and report to us. Many of them are willing to come in and use their names, have their identities known, and aren't afraid to do it. They're incredibly courageous for doing that, but they do it. Many are afraid and don't want their names known. They want to be anonymous. Others send us information through our hotlines, and we never learn their names. Doesn't mean we can't follow up on it, but what we've got to do in those instances in particular is see if we can corroborate the information. And that's really what we're charged with doing. We want information. We want people to come in. We get, in my office, over 10,000 calls to our hotline a year. We've got to sort through them. Not all of them develop into leads. Not all of them, when we investigate them, develop into findings. But they're critically important, and that ability to come in and without fear of retaliation or the threat of retaliation is critical. And we as IGs have to do our job not only educating people so they will come in, but also making sure that if anybody's threatened with retaliation, we do our jobs to ensure that there's accountability if that occurs.
Well, I certainly get this through your testimony, but I just want to reiterate and get your response. It seems to me, based on the importance of confidentiality and the fact that you don't just act based on a confidential report, you actually have to corroborate it with actual evidence. But how you mentioned how important confidentiality is, so I suspect that identifying the identity of a whistleblower without their consent would likely to have a very significant chilling effect on whistleblowers generally. Is that an accurate statement, if you could expand?
Yeah, that's a fair statement, and in fact, Congress and the IG Act has told us we're not allowed to disclose whistleblower identities precisely because of that reason, unless there's a legal requirement that we do so, unless we're unable through other means to protect their identities. So, look, people who come forward, it takes great courage. My first involvement in this as IG was when I walked in and Fast and Furious was ongoing. We had courageous whistleblowers from ATF come in and report that information to us. Most of those individuals put their names